by a person who was of sagacious, righteous, non-profligate, honest, and good character.
Yes.
Yes.
But the point is, 18th Amendment stamped on it. You see,
My
that's
lord,
the-
8th Amendment stamped on it.
No, देखिए,
And then 18th Amendment stamped.
Mr. Makhdoom Ali
My
Khan,
lord.
at least now I will speak for myself, I don't know. Wherever this is one way of interpreting the Constitution, and I've held it in a judgment or two, that wherever there is problem areas or difference of opinion or two interpretations possible, at least I've chosen the one interpretation which found mentioned in the original pristine constitution chosen by the directly elected representatives of the people and not martial law administrators. Why are you so scared of martial law administrators to utter these words, Mr. Makhdoom Ali
My
Khan?
lord, may I submit that this is also the jurisprudence of this court. In Al-Jihad case, Mr. Justice Ajmal Mia took the view that if there is a conflict or tension between two provisions of the Constitution, one which was enacted at a time when the Constitution was in abeyance and other at the time when the Constitution was in full force, it is the latter which will then prevail, and that view has been reiterated in Samiullah Baloch, though
Mic
the
check.
principles drawn from it thereafter are different. So what your lordship is observing,
So where is it mentioned in Samiullah
Hi,
Baloch?
mic
my
check,
lord,
mic check,
in
mic
the
check.
Samiullah Baloch case itself,
No, I just want to read that part.
yes, my lord, your lordship will see the constitutional principle is identified in the Samiullah Baloch case itself at page 435.
Huh?
Page 435.
At this point that you are saying.
Yes, my lord. This point is there on page 435. This is PLD 2018 Supreme Court 405.
Which paragraph are you reading?
Paragraph 22.
G.
If your lordship will see, there are a number of judgments cited, and then it says reference by the President, PLD's 1957 Supreme Court 219 at 235. As such, the Constitution must be interpreted as a whole because it is an organic document that is meant to apply to the changing circumstances of time and space. Consequently, each provision of Constitution or part thereof has purpose, meaning, and integral place that must be understood, acknowledged, and applied harmoniously. It is only when a conflict between two provisions of the Constitution is irreconcilable and one of such provisions was inserted when the Constitution was held in abeyance, then the provision which was made part of the Constitution during the period of its abeyance would yield.
But would it apply because after the 18th Amendment having stamping it, so it's not really, that was a democratic dispensation at that time.
My lord, it was, but your lordships prior to this also in Al-Jihad's case took the view that in spite of the fact that whatever General Zia had done had been validated to a large extent by the 8th Amendment to the Constitution, this honorable court took the view that, and that was in particular, my lord, in relation to a provision where a judge of the High Court declined to go to the Federal Shariat Court and was as a result sent home. Their lordship took the view, particularly Mr. Justice Ajmal Mia, that this provision was inserted at a time when the country was going through a period of constitutional abeyance. No doubt it was validated by the 8th Amendment, but if when we examine it and juxtapose it with other provisions relating to judiciary, this having been added at the time cannot be allowed to hold sway, and that is why their lordships held that a judge of the High Court cannot be sent to the Federal Shariat Court against his will, and if he refuses, will not cease to hold the office of a judge of the High Court. So, in spite of that, this has been the jurisprudence of this honorable court, that in spite of the validation,
Mr. Makhdoom Ali Khan, but would you put validation at par with an original enactment which has been thought about, carefully considered by every member of parliament? A validation was also a bitter pill for the parliamentarians to swallow. If you don't validate, I continue. So it may be that, okay, we are getting something, is better than nothing, let's at least get on with it. But we are now faced with a problem. So simple validation when the original constitution said something else, if there are two possible ways to interpret something, and more so when what has been added is very ambiguous. I don't know why these vague words were introduced. You could have simply said A, B, C, D, like every other thing is factual. Either it's a yes or it's a no. Are you of good character? Please don't answer this question. But which person would say this? I mean, it would be a very audacious person who would say, I'm honest, Ameen, and everything. And then probably he will be making other claims which will be totally not permissible. So simple validation is a bitter pill which has been swallowed from time to time to get democracy back on the rails. Would you not agree with that, since we consider you a constitutional expert, to consider validation at par with a constitutional provision, or it has to be read in the context of, because this judgment also says in space and time. The space then was a dictatorship. Either you continue another 10 years of a dictator or get some sort of a diluted form of democracy, get us back on the rails, whichever is better. So probably the parliamentarians, we should not always condemn the parliamentarians. We should see the difficult circumstances that they work under. I mean, we should respect them. And what would you have done? Let's put yourself in the position of parliament, make yourself a parliamentarian then, that you would, validate something which you may not be very happy with, but at least get the business back on track. How would you personally attend to it?
My lord, my respectful submission is that though the earlier two judgments which I have just identified by this honorable court do not put it in the terms that your lordship has, but that was probably at the back of their mind when they said that an amendment made during the period of constitutional abeyance, if it is in conflict with or cannot be reconciled with the provision originally enacted in the constitution, then the latter will prevail. So obviously this honorable court has not treated the validation at the same level as the original constitution, recognizing all the difficulties which your lordship have articulated, but not articulating them in this particular manner. Otherwise, my lord, if any amendment made to the constitution eventually when made stands on the same plane as any other constitutional provision, but your lordships have held that we will distinguish between constitutional provisions made during a period of constitutional abeyance.
What's your main argument? Is this your mainstay of your argument?
My lord, my main argument in this particular case would be that insofar as when your lordship examines Articles 62 and 63, because some of these amendments, as your lordship has just now noticed, came in at the same time, there is a relationship between the two. And with great respect to this extent that Samiullah Baloch says that 62 and 63 have to be looked at through different lenses, it is with great respect incorrectly decided.